It's interesting to be here because my daughter has Prader-Willi syndrome, and I'm the president of the Prader-Willi syndrome group in Utah, and we meet here for all of our stuff. So it's like it's just different faces, but the same. How do you get to belong to this club or that club? So just a couple of quick thoughts to start with. When I talk to attorneys and tell them that I do this, they say, don't do this. You know, you should have them all come into your office and figure everything out. And that's true, but I also know how hard it is as, you know, we actually have 5 kids and 2 of them have special needs, and I know how hectic life can get and how much you spend all of your time running to therapy and doctor's appointments and trying to figure all of that out. So anyway, so as parents of children with special needs, we just want to have them have this wonderful, happy, great life, and we want to be able to take care of them the whole time. But that's not necessarily the reality. A lot of our kids live longer than we do, and so you've got to have some plans in place for them. And so we're going to talk for just a minute about the different legal plans that you should have. And there's an article on your table that has a picture of me and my daughter, if you want to grab that. It basically outlines what we're talking about today to some degree. So that will be a nice guide for you to take home. But when you have a child with disabilities, there's several documents legally that you should have in place. So as was mentioned, you should have a guardianship in a lot of situations, and you'll have to decide that, but you should have a guardianship over a child who is 18 and doesn't have the capacity to live on their own. You should get a power of attorney. Both spouses should have a power of attorney at some point. A medical directive should be had by both spouses, and it's called a Utah Advanced Healthcare Directive now, but that's kind of the living will is what it used to be called. You should have a special needs trust for your child, and you should have a will for you and your spouse, or if you're single, just for you. And then some parents will want to consider getting a revocable trust for their estate, which is helpful as well. So once your child reaches the age of 18, the law considers them an adult, and you're typically not able to make decisions for them. You're not their legal guardian, and they're presumed competent to make all their own decisions. A lot of times doctors won't let you come into appointments anymore because of the HIPAA regulations. Social Security often won't talk to you about their finances. For our children, they run a lot, and so if they run away and they're an adult and you don't have guardianship, often the police will say, no, sorry, they're an adult, they can go wherever they want. So a lot of these things, and you would have to know your child and where they fit on the spectrum. With most of our children with our syndrome, you get a guardianship. But you just have to kind of know. The courts will look at whether they're competent to make certain decisions, to take care of their physical necessities, to handle their money. If they're able to do all of those things, then the court is not going to give it to you. If you're questioning and think that you probably should, then my suggestion as a parent, not as a lawmaker or whatever, they would say, you know, let them be an adult and do what they want. But you know the limitations. So as a parent, most parents will let their children do what they can do. And so if you're questioning it and there's a chance that you need it, my suggestion is to try to get it and then let them soar and go as they will, but then you have some authority to help them make decisions if you need it. You need to get an attorney for your child when you do this. It's absolutely required under Utah law that you have an attorney for your child. You can represent yourself if you want. And there's a lot of places like the Guardianship Associates, different companies that you can go for like $70 and take their class, and they'll help you fill out the forms to represent yourself. Or you can get an attorney to do it so you don't have to hassle with anything. But you can do it yourself. But you do have to have an attorney for your child to represent them, and so the attorney will discuss it with your child and make sure that your child, you know, needs a guardianship at age 18, and they will represent that to the court. Again, as was discussed, you should always apply for Social Security income when your child turns 18. It's a lot easier to get if you do have guardianship, at least for the people that I've talked to that have done this. The maximum benefit right now is $674, which isn't huge, but what's the other reason why you would want to get Social Security for your child? Medicaid card. So a lot of us, our insurance won't cover our children once they get past 24, 26, whatever the magic age is that your insurance says, and who knows with all the new legislation what's going to happen, but that's the situation as it stands now. So even if money isn't an issue for you and that money that's coming in isn't a big deal, then you definitely want the Medicaid card. The other thing is a lot of parents say, I don't need that money and I don't want to hassle with the government. But first of all, the Medicaid card. Second of all, why not take that money and put it into something? I mean, you have to use it for certain things, but that frees up your money. Why not put that in a trust for your child? Do something that's going to help your child down the road. So power of attorney, this isn't a huge deal, but oftentimes, a husband will leave to go start a job in another state, and you're left, the wife, to sell the house and to take care of everything. It's nice to have a power of attorney so you can sign documents for your husband or you can act for your spouse. And so it's just nice to have that document in your files to make your life easier. Medical directives you all should have, where it says what happens to you if anything happens medically to you. Again, these you could Google like Utah Advanced Healthcare Directive and pull one up and fill it out yourself. You don't have to have an attorney do that. And a lot of people say, "I just pull the plug." If that's where I am, just pull the plug. But you've got people to take care of. It's not as easy to just say those kinds of things. And often you could be on a ventilator for a week and recover and be able to function. So you need to look at that seriously and fill that out in light of what your life situation is. Okay, then both parents should have a will. And what this does is it allows you to say where your assets go, and it allows you to determine a guardian for your child with disabilities and for your children who are minors. And so that's a really important thing to have, where you've named a guardian. And one way that I like to do it for families, especially younger families who are starting out and don't want to spend a lot of money, is I like to do a will that has a special needs trust within the will. And so what that does is it allows parents to set up a way to take care of their child with special needs or with a disability. So what happens if you have Social Security income, if you happen to be able to get on DSPD, which a lot of people don't, I don't know how many of you know what that is, and if you have a Medicaid card, if you have different kinds of government benefits, typically if you ever have more than $2,000 in that child's name, then they will lose the benefits and then have to reapply and figure everything out again. And if you're on DSPD, a lot of people have waited for years to get on, and if you get thrown out of that, it's not a great thing. So what you need to do is have a special needs trust set up. So if your child inherits money from you, if you died, likely that child would inherit more than $2,000. I mean, a lot of us don't have a lot of money, but if they sold assets and sold what you had, if you don't have a will, it will come down to your child. And so you need to make sure that you've got some mechanism set up so it goes into a fund that can be used for your child without causing them to be disqualified from their benefits. And again, an easy way to do it is just to incorporate that right into the will. And I have forms for that if you wanted to talk to me about that. A lot of these seminars, and like for our families, I just emailed it to them and let them fill it out, which is better than waiting to go find an attorney and coming up with a few thousand to do it. So some of my information is there's an email on there, and if you're interested, I could send you one of those to fill out. It's not a hard thing to fill out, and at least you would have something in place that would protect you. And, eventually down the road, it would be nice to go sit down and meet with an attorney, but at least you would have a start to get something done. So keep in mind that when you do this kind of estate planning, that it's not your first and last attempt at it. You need to look at your life and how it changes and be evolving as you go. One thing that older families, maybe older like me, that you start to your kids are getting older and everything, you might want to look at a revocable trust for yourselves where everything happens automatically. If you have a will, when you die, you still have to go to court, your heirs do, and you have to go through probate, and it takes 2 or 3 months to get everything figured out. 2 years in California, we're a little luckier here. But with a revocable trust, everything happens automatically. You could have a trust set up for your child, and there's a checkbook already there, so if somebody has to come in and start taking care of things, everything's just ready to go immediately.